की तारीख में पहली बार सुप्रीम कोर्ट की कार्रवाई बराह रास्त नशर की जा रही है। आपको बराह रास्त लिए चलते हैं।
My Lord, my first submission on whether these petitions raise or they raise any issue or question of public importance. My Lord, my learned friends, the counsels for the petitioners, they have largely, their case is rooted in lack of legislative competence, not necessarily objecting to the contents, all of them, but it's essentially rooted in lack of legislative competence of Parliament in terms of Article 191. And the argument, my Lord, is that because the powers and because this Honorable Court in 1980 had made rules, therefore the field stands occupied, and in any event, Parliament could not legislate. My Lord, firstly, insofar as public importance is concerned, my Lord would have now gone through the law, and my Lord would see that this law, in fact, deals with the concentration of powers, barring one provision, but concentration of powers in one office. What this law endeavors to do is, it democratizes this institution, brings more transparency, and structures the discretion, which is something, this structuring of discretion is something which has found favor with this court. The 7 principles enunciated in Amanullah case, PLD 1990, Supreme Court 1092.
PLD
1990, Supreme Court 1092. Open policies, open plans, transparency, and so on, which this court has held that it is required of every, and of course it was with regards to the powers that the executive exercises. Now these are all administrative powers we are talking about. This law deals with largely, barring, of course, Section 3. There was a question that was raised. I'll address it towards the end. And Section 5, which I will address separately. So insofar as public importance is concerned, this law, in fact, deals with the issues which are important for public, which is the litigants. Secondly, insofar as independence of judiciary is concerned, my lords, there is no external element, which is to say that no other institution which has given any role whatsoever under this act insofar as practice and procedure of this court is concerned. It is all confined within this court. And that alone suffices insofar as the lack of any basis to challenge this act on the basis of violation of any fundamental right, because Article 9, yes, Article 9 as expounded by this court, access to justice and of course independence of judiciary is something which is which every citizen of this country is entitled to. So my respectful submission insofar as maintainability is concerned, these petitions fail on both counts. My Lord, in continuum, as far as independence of judiciary is concerned, and I take your lordships to page 6 of this paper book. Starting from Government of India Act 1935, which was the first constitutional order of this country, under which Federal Court rules of 1950 were made. Under Section 214, subsection 1 of Government of India Act, the Federal Court could make rules, but with the prior approval of the Governor General. at that time. And in 1950, the Governor General, of course, was neither part of Parliament. There was no constitution, but under the Government of India Act, Governor General wore several hats, and the executive authority vested in him, and of course part of some legislative authority as well. Under the 1956 Constitution, Article 177, read with third schedule, Part 1, Clause 3, the rules were made with the prior approval of the President. There was not even a mention of any law as far as the 1956 Constitution is concerned. 62. Under 1962 Constitution, Section 60, Article 65 said, subject to this Constitution and the law and with the prior approval of the President.
In 56 Constitution, the rule-making power was contained in third schedule.
Yes.
Had to be read with Article, I forget.
177.
That said
subject to law, and then...
No, that said subject to law. It said subject to Act of Parliament.
Act of Parliament, but I'll address that, which my Lord has just pointed out. I will address, my Lord, that question. My Lord, as far as... Just bear with me, my Lord. Sir, एक second. I'll just Article 177. I'd read it out just for clarity. Until other provisions are made by an Act of Parliament, third schedule would apply. And as far as 1956 Constitution is concerned, nothing happened under that Constitution, but the Constitution provision was until an Act of Parliament is made with the prior approval of the President.
56 rules were made. Rules were made under the 56 Constitution.
56 Constitution, and Act of Parliament was not made. 56 rules came with the prior approval of the President.
Is there any
so as far as...
Is there any difference between Act of Parliament and law?
I'll address that question, my Lord. This is a question that I've noted, I'll address it. Under the 1962 Constitution, Article 65, subject to the Constitution and the laws, Supreme Court could make rules with the prior approval of the President. And same position, it was same position under the interim Constitution of 1972, which is Article 193.
I'm sorry, my apologies to interrupt, but the question here is surely when Governor General is referred to and the President is referred to, that's the executive branch. The 73 Constitution had the models from going back to 1935 up to 1972. It eschewed the controlling power of the executive branch. So surely the argument there is that the framers of the Constitution expressly were trying to strengthen the independence of the judiciary, and at least, if I may use the term, eliminating one particular branch from the equation. So the argument perhaps is the reverse of what you are saying.
No, I'm coming to that. I'm coming to that.
In mind.
No, I have it in mind. I have it in mind. When I went through this, I noticed that the executive branch was removed, but not the legislative branch. So this is the effect of 1973. This is what has happened in Article 199. The executive action was...
It's a pointer in that of the direction in which constitutional law is traveling.
I'll address that. In India, my Lord, under Article 145, Clause 1, it is subject to law and with the prior approval of the President, and so is the position in Bangladesh under Article 107, identical to what is in India and what we had under...
In the Constitution, these references, when they say subject to approval of the President, is it unilateral discretion of the President, or it is President advised by the Chief Executive, albeit the Prime Minister, whoever that is?
My Lord, so if we look at the jurisdictions where we have this position, of course in India, he acts on the advice. And if, for example, under Article 191...
Government has the last say, not Parliament.
Yes. It was, no, my Lord,
with a distinction. The prior approval of the President means effectively prior approval of the Prime Minister, not the legislature.
Yes.
Okay.
Yes.
You said that in the Indian Constitution also it says subject to law, but that provision doesn't read like that. It's subject to the provisions of the law made by Parliament.
Yes.
So it's not subject to law.
I will come to that when I take you to Article 191. I'll come to that. I'll come to that when I take you to 191.
I'm just clarifying जो आपने argument की.
My Lord.
वहाँ ये नहीं लिखा हुआ.
When I'll address subject to law, I'll be addressing.
Page 7 page you reproduce.
Page 6 and 7, yes, my Lord. Now, in other jurisdictions, in United States, for example, this is 28 US Code, Chapter 131, Section 2071. The rules made by the Supreme Court have to be consistent with the acts of Congress. And the latest development, or later development, is the Constitution Reform Act of 2005 of the United Kingdom. Now, under Section 45 of that act, the President of the US Supreme Court makes the rules, but he's required to consult with the Lord Chancellor and all the bar councils while making the rules of procedure. So this is the progression, or this is how this is the system that we have in place.
2000 UK Act, does that
2005.
2005 UK Act, for example, do the rules have to be placed before the Houses of Parliament, or is there any involvement at all by the legislative branch?
There is none, but
he has to consult.
He has to consult. Now, whether
with other than the Lord Chancellor, who is a dying breed in the sadly in the UK system, but anyway, it's not. Parliament has made the law despite their rule of sovereign legislative supremacy. The Parliament itself has said it's got to be totally independent of us.
Yes. And for that, now, I take your Lordship to Article 191. Now, this is where I will address what the term law means and what is the scope that this term has, and whether an Act of Parliament would be actually covered under the term law or not. Or whether we can give it a meaning where an Act of Parliament would be excluded from the definition of law and everything else would come under the...
Why? I don't even understand this debate. Why is this? What is I couldn't understand the point of counsel. What was he saying, really?
My Lord, the counsel was arguing, began by referring to Clause 1 of Article 8, where it said that any law or custom or using having force of law, etc., shall not be made, and then Clause 2 said that places a limitation